I sit on the Women Leading in Privacy boards at the IAPP, as well as co-chair the local Kenyan chapter for the IAPP. I also sit on the board of the Kenya Privacy Professionals Association, and welcome all of you to join. I think we are lawyers here, so we are all in this space practicing, helping people with data protection. We invite you to join the Kenya Privacy Professionals Association, and then I'm also a member of the LSK Nairobi branch ICTIP committee, and as Josephine has said, co-moderating this session along with her.
Okay, thank you so much for that, Mercy. So you'll allow me to also introduce the panelists we have. So I'll just briefly go through their profiles, and then we can now kickstart our webinar. So with us today, we have Miss Louisa Matu Mureithi. She holds a Bachelor of Law from Nelson Mandela Metropolitan University and a master's degree in intellectual property law from the University of Cape Town. She previously worked at CPIT in an open air project, and she's currently working as a group data privacy manager at the Equity Bank, and she is an expert in data protection. So Louisa, do you want to wave and say hi? Louisa, you can just wave
sure.
and say
Hi, everyone. Hi, everyone. Hi, everyone.
Okay, karibu. So I'll go to the next panelist. We have Miss Anne Mudeu. She's an advocate of the High Court of Kenya and a managing partner at Mutie Advocates. She began practicing law at the firm of HHM, where she served as a litigation advocate from the year 2011. Thereafter, she left to dig her heels into in-house practice, and she served as a departmental head in various local and international organizations. When it comes to her education, she has a Master's of Law in Corporate Law and Insolvency from Nottingham Trent University. She also has she has certification in mergers and acquisitions, a diploma from the Kenya School of Law, and a Bachelor's of Law degree. So, Anne, you can wave and say hello.
Good afternoon.
Great. So allow me to also introduce the third panelist who is with us today. So we have Janet, and Janet has expertise in the fintech, regulation, tech, cyber resilience, advisory, and data privacy governance. She has been able to work in this particular sector, and which is of course dynamic. It has a lot of innovations and all. So she's one of the few privacy practitioners in Kenya who have received training and certification relating to GDPR. I'm sure she'll be able to tell us more about that. She's also a certified data protection officer. She is a thought leader in TMT and is continuously publishes on regional and international sites such as CIO and AfriWise. So she has previous experience in other practice areas that, of course, have proved useful in offering holistic legal services for a wide range of clients. So, Janet, maybe wave to the people and just say a quick hello as we start.
Good afternoon, everyone.
Yes, so as we can all see, we have a rich panel when it comes to data protection. So how the format of our webinar will take place, we'll be looking at the topic from two perspectives. As we've noted, the topic we're looking at today is data protection in the recruitment cycle, from the applicant to the employee. So for a start, we'll look at data protection compliance matters. And then later on, we'll also look at secure handling of data. So I'd like to invite Mercy to take us through the first session of the webinar, where we'll be discussing matters compliance. So Mercy, maybe you can take us through.
All right, thank you so much. So maybe for the panelists, when you're picking the questions, you can please just put your camera on and unmute yourself so people can see you as you respond. And then for the rest of us, please keep your camera off and your mic muted if you're not speaking. Thank you all. So the first question, maybe I'll begin with Luisa. And maybe you can tell us, what are the key legal considerations surrounding data protection in the recruitment process? So during recruitment, a soft light question to begin us today.
Yeah, thanks for the soft light start off, Mercy. Yeah, so some of the key considerations I think would be, according to our Data Protection Act and others that consider gold standard, including the GDPR worldwide, would be to ensure that whatever your organizations do is lawful and transparent regarding the processing of data in the recruitment process. I think it's very important for whoever your applicants are going to be very transparent of the kind of personal data you're asking them for, why you're asking them for it. If you're going to outsource the recruitment to an external company, then explain to them exactly what they're going to be collecting and why they're going to be collecting, and if they're going to be doing it as a processor on behalf of you or both data controller and processor, then what that means. You also have to ensure that you obtain consent in the different bits, if that's a legal basis you're using for processing the applicant's data. And also, over and above informing the candidates of the data usage, it's important for you to maintain data security. So if there's going to be any cross-border transfer of this data, and that also includes storage, then you need to ensure that you explain this to the applicants and explain to them that the data will be stored and only accessed by the people who need to access it.
Okay, thank you. You said controller, processor, very big words. I don't want to assume that everybody on this call understands what that is. So kindly just help those who are not up to speed, just understand who's a controller, who is a processor.
Okay, that's fair. Those are words we throw around in data protection, and not everyone may understand what they mean. So a controller generally is the organization or the person that would collect the data. They also, this personal data in this case, and then they would also determine and give instructions to the processor, who's usually a third party, on how to process the data. And then a processor would process the data, but that processing is very wide. So it means anything from storage to any sort of manipulation with the data, etc. And both these parties have rights and obligations in terms of our Data Protection Act and also globally. So that's what a controller and a processor do in general.
Okay, thank you, Luisa. Yeah, so for anyone who was wondering what those are, she has answered. So data controller, mainly the person who determines what type of information to be collected and what is to be done with it. They can also decide whether they want to collect or process it directly or hire someone else to do it, while the processor is the hired hand to come and help. Best illustration, the house is yours, but you can bring in a domestic house manager to help you do the chores, okay? Controller is the owner, my house, my rules. Processor is the one who's been hired to do it. So that's just a simple explanation because that is important for the rest of this conversation. Thank you, Luisa. The next question goes to Janet. Now, Janet, maybe you can help us understand how can organizations ensure that they comply with the Kenya Data Protection Act and other data protection compliance obligations with regards to their recruitment activities. If possible, you can also give us some practical examples to help people understand.
Thanks, Mercy. Just to follow up from what Louisa said, we are all too familiar with the recruitment process. I mean, some of us started at pupillage, internship, to some of us who worked in-house and those of us who applied to law firms. And the recruitment process initially, without betraying my age, for some of us was very manual in terms of printing a CV and dropping it at a reception. For most people nowadays, it's an online portal. You fill in certain information. You might provide access to your LinkedIn page or you may just upload your CV as it is. So it's a balance of both, depending on the organization you deal with. And it's more of you submitting a lot of your personal details or your personal information. Now, data protection is all about protecting personal information, and personal information is any set of information that may identify you as a natural person. So we're looking at things like your names, your online identifiers, such as your LinkedIn or your email handles. We are looking at your phone numbers. We are looking at your race. We are looking at your sex. We are looking at things such as your date of birth, your ID number. And all these things, if they are put together in certain sets, they should be able to identify you. So during the recruitment process, depending on the organization you're applying to, how do they receive in the information? Is it at the watchman at the gate, or is it the receptionist at the secretary, or is it an online portal? Once they're received, how are they dealt with on the back end? Who has access to this information? Who is managing this information? Who is processing it further? And do some organizations rely, like Louisa said, on third parties? Are you going through a HR recruitment agency where you submit the CVs, then they're submitted to the controller, aka the employer, or are they, or are you directly interfacing with the organization? So they're sitting now on, let's say, droves of CVs, and the positions they're looking for is probably 2 applicants to fill in the position. In such a case, they've collected up to hundreds of CVs. They've done the shortlisting in the normal process they do. They've come up with the best of the 10 or 15 CVs. What do they do to the other 85 CVs? Do they return them back to you? Is there a return address on your envelope? Does the portal notify you that we don't need your CV and we're returning to you? Or is the standard answer that you get on most of these portals, we may keep your CV for some time in case something comes up? So is that what you're dealing with at the back end, or is that something that is, we can say they've enshrined in their policy? So like Lisa said, at the outset, employers or prospective employers need to have, and most of them have the habit of just our privacy policy link here. But the privacy policy is very general. It provides for all sort of scenarios, including how they interface with their customers. But you're not trying to interface with this organization as a customer. You're trying to be a prospective employee. There's no employment contract yet, but that's where you're trying to get at. So in between, what's the kind of relationship you have with these people, and what sort of measures or what sort of assurances are they giving you? So it's very important that organizations have very specific employment or recruitment policies that outline what it is they seek to achieve with their data protection and privacy policies. Like Louis said, are they being transparent to tell you that, yes, we've received your application? Yes, we are going to shortlist it. Yes, we will use it to get back to you to come for an interview. And yes, we will use it to appraise your skills or just look at your qualifications to see whether you are suitable for the job. And if you're not suitable for the job, this is what we call our retention policy. So retention policy basically speaks to the fact that we keep your records for 3 years, for 5 years, for 10 years, and after that we destroy them or we expand them from our system. So organizations need to be very upfront and need to be very alive to that information being communicated at the outset before people are able to submit any sort of personal information. Again, the other things that you can put in place is probably to just have an impact assessment, a data privacy impact assessment, to know if we are going to be receiving CVs from 100 Kenyans, 100 Europeans, 100 Africans in general, what sort of data sets are we looking to sit with? What sort of risks are we looking at? And is it appropriate that we collect it in this format, or do we collect it in this format? And you really have to respect a lot of people who do not want to collect a lot of data. So they'll tell you, just give us the link to your LinkedIn, and from your LinkedIn, we will be able to see what we need before we can shortlist you for the second round. And this reduces your exposure in terms of just sitting with a lot of data sets. So those are some of the principles, some of the procedures, some of the technical safeguards that organizations can look at in terms of just ensuring that they comply with the Data Protection Act, but also ring-fence themselves from sitting on a lot of unnecessary information, but also inspire a sense of confidence in anybody who's trying to apply for the job.
Thank you very much.
Yeah, sorry. And in conclusion, I'm sure you've all seen the case that's been going around of Faulu. And because this is a privacy forum, I will not mention the name of the complainant, but you are aware as to what are some of the challenges that employers are facing in collecting data, holding on to this data, and not being able to know how to use it eventually.
Maybe you can just give people a 2-minute overview of the Faulu. Yeah. Some people don't know.
Okay, this gentleman applied for a job at Faulu. Faulu, as you understand, is a regulated entity within the financial services sector. And for certain positions, definitely for certain positions, there are regulatory requirements, but also industry requirements that they need to do a background check, especially on any criminal activity for people occupying certain positions within the institution. So when they did their background check with the previous employer, this gentleman had not disclosed there was an ongoing or a court case relating to criminal activities that was attached to his name. The previous employer disclosed that. So this gentleman had passed the initial stages of the interview and was just about to be offered the contract. But the organization withdrew the contract once this information became apparent to them. So when the gentleman put it to them that, yes, you're withdrawing the letter, but I need to know, can I have the details of the information you have that is making you withdraw this offer? And the response Faulu gave them was that this is private information, we can't give you. Yet it's personal information touching on him. So he took the matter to the ODPC, and the ODPC sided with him on that, in that as long as it is personal information, he has a right to access it.
Thank you, Janet. So one, results for interviews and the reasons you're doing or not doing things. Personal data that a subject is entitled to. Secondly, also, I think Janet has highlighted the importance for organizations to consider having a standalone privacy notice for applicants, job applicants, because most entities have notices for customers. Some have for employees, not all, but very few actually have standalone for applicants, because applicants are in sort of like a different category of data subjects from employees. So that is also something that, as lawyers, you can advise your clients to do. And if you're in-house here working, in the legal department of an entity, do you have a standalone notice for applicants? That is something to consider. Thank you, Janet. Now we'll move on to the next question, which is for Anne. Anne, I know you do lots of trainings for the College of Human Resources Management, and you are often training HR and helping them grapple with the realities of this with regards to applicant information and employee information. So tell us, what are some of the common mistakes organizations make when it comes to data protection compliance in recruitment, and how can this be avoided? Please enthrill us with the stories and practical examples that you've encountered in your practice.
Thank you.
Tafadhali.
Thank you, Marcy. I don't know whether it'll be thrilling, but I'll give it my best try. So I think, just speaking from what Janet has said, one of the things or the challenges that organizations are facing is just how to provide this privacy notice. Because Section 28, I think, or 29 of the Act says you give it at the time you're collecting data. And a lot of the ways we receive CVs are either through a dedicated email address, or if you're coming through an applicant tracking system, or even a referral. So how do you make sure that the employee sees the notice? Because that is the important. If they don't see it, then you don't meet the transparency requirements. So there's a little bit of innovation that is required. For example, if you're using a dedicated email address, how can you automate it such that when the CV is received, there's an auto response that actually has a link to that privacy policy. So at the end of the day, you will not satisfy transparency by placing the notice on your website. If they never saw it, there is no transparency. So that's one of the challenges. If they drop it to your offices, how do you ensure you meet the transparency requirement? Are you going to tell them, go to the website? Or is somebody going to be sitting there saying, thank you, I've received your CV, now here's my job applicant privacy policy? So that's one of the challenges that we have seen. Another area or another interesting scenario is how to minimize collection of data. Sometimes in the very large HR departments in an organization, you can have multiple people doing recruitment and multiple people asking for different things. So you find you do not have a standardized way of seeking, and some people are seeking too much information at different stages. So how do you ensure that you comply with data minimization in such a scenario? And one of the things you can do is to ensure you have a documented recruitment policy. Most of our recruitment policies don't talk about what data we are collecting at what stage. So why can't you then list that at the first interview, I'll only ask for a CV. At interview number 2, you will come with your originals, but not copies. Interview number 3, I'll probably now need copies because it means I'm taking you to the next level. So it needs to be standardized so that you avoid having people doing different things within the same organization. But then it also needs to be thought through that you don't have too much information being collected. When it comes to shortlisting, are you using a system? If you're relying on an applicant tracking system, how are you making sure that your job applicants understand the logic that is involved in your ATS systems, because we know that's automated processing? Is your privacy policy talking about what could happen to them, the consequences of this automated processing, that they could actually miss out an opportunity based on how your algorithm is? And also, have you told them that, you know, they have a chance to object or to raise a complaint if they feel that the process was not fair? And do you have a mechanism in place to enable you to address that issue when and if it arises? So there is issues in shortlisting, there's issues in interviews. If you do Zoom interviews, if you do Google interviews, or whatever kind of virtual interviews you're using, are your platforms secure? How are you going to ensure transparency? Do you need to record? Is that too much information, or is it relevant? So those are some of the scenarios and things you need to think about. The pre-employment check, actually, you can see already, is the biggest area of litigation that we have, or the area of complaints that we have. And it's unfortunate for us in Kenya, we actually don't have a standard guideline from the regulator on what is acceptable. So right now, the employers are kind of flying in the blind. Everybody's just going out there and, you know, saying consent is the way to go. But even consent can be challenged. If you look at the regulations, it says if I'm giving you consent and it's presented as part of a non-negotiable term and condition, then I can challenge it. I can challenge the basis upon which I'm giving you that consent. So that becomes another area. Is the consent you're seeking from the applicants valid? Can it be challenged even if the ODPC sides with you? Can the complainant go to court and further challenge your consents? Again, in pre-employment checks, you have to think about the types of checks you're doing. What depth of checks are you going to do? Is it going to be just about your academic background? Are you going to look at people's papers? Are you going to look into social media? You need to have documented a policy that talks about your depths of checks. And these also need to appear in your privacy policy as part of transparency and transparency requirements. You need to think about retention. How long do you retain recruitment data? And I have seen all sorts of scenarios. I have seen people who have CVs, 15 years worth of CVs. I have seen others with who delete them in 1 year. I have seen boxes upon boxes. There's a room in the HR office where nobody goes because those are all the old CVs in boxes and nobody ever visits them. So what's the standard? What's the guideline? Okay, so we don't have any official guideline on what should be in your retention policies, but you can use the Employment Act as a good guide, that you would not get an employment case, you know, beyond the 3 years. That's the time limitation. You can consider the fact that you could get sued. In this environment of data protection, it's very possible you'll receive legal suits coming from job applicants. So you do need to keep the information to just have a record that you actually dealt with somebody, but you don't need to keep it beyond, say, the 3 years. And again, also you think about things like volume. How much volume of this data do you have? And is 3 years a reasonable period based on your own looking? So I think the issues are many. I don't want to deal with all of them here, but there's one other one in background checks that I think is important. We focus a lot on what you should seek from the person when you're giving the check, but there is also what can you ask and what can you say as an employer. You can also be sued for what you say, because if it is not factual, then you're trending on accuracy, and you will be challenged on the accuracy of your data. So if you're asked for a reference, what are the parameters? And I think this is one of the areas that the regulator can guide, because what is happening is employers are becoming grade and just settling at the certificate of what do you call it?
Certificate of service.
They are saying all I'll give you is a certificate of service, which then compromises the nature of people we are going to hire. If every employer says that, then nobody's going to give factual information. So I think I'll stop there.
Thank you so much. And that was very insightful. 15 years of storage of CVs. All right. Louisa, could you please help us with providing some examples from best practice for handling candidates' data while ensuring compliance with data protection laws? Just a few examples.
Yeah, sure. Happy to help. That's what I always say on my emails. Yeah, so some of the examples that you could apply as best practice include only collecting the necessary data, which both Anne and Janet have alluded to. That means that you're sticking to the principle of data minimization. Also, you should ensure that you're storing it securely. And then I'd also brought up the issue of if you're going to have any cross-border transfer or storage of data, that's important to ensure that wherever it's going to be stored, you have adequate and technical organizational safeguards in place, especially if you're going to be using a processor or a cloud storage service. And also, if you're going to be sharing any information on data on the data, then it's important to then tell the clients that, or tell your potential candidates that you're going to be sharing the data and exactly whom you're going to be sharing the data with, and also offering the candidates the right to access, which is one of the DSARs, as we call them, the data subject access rights, and that also includes then the right to rectify any of their data that they may have submitted that may be incorrect. And our Data Protection Act and regulations also has certain timelines for certain DSARs to be completed. So if a subject submits a request, even if it's not directly to you, if you're in-house counsel or part of the data protection team, then you need to ensure that you then implement the right within the time. And also, if you're not going to, then you also have a legal obligation to then give them a written reason as to why you wouldn't be doing that. Yeah.
Thank you so much, Louisa. Clearly, like you said, accuracy. If you keep a CV for 15 years, it is definitely not accurate. Okay. So those are things to advise your clients on. Thank you so much, Louisa. And now we'll be moving to the next segment that will be focusing on securing data handling. Josephine, please take us through the questions around securing data handling.
Okay, thank you, Mercy, for that. And indeed, it's been an enjoyable first session. So as we proceed, the first question, I'd like to pose this question to Janet. And for Janet, kindly tell us, how can organizations ensure ongoing data privacy for employees after they've hired them?
Thanks, Josephine. One thing to actually note is that before Data Protection Act, there were other industry standards. There were just other ways of doing business that ensure that the HR department, the HR and probably payroll department were some of the most confidentially treated. The way they dealt with employee records was in a very confidential manner, in a very private manner. So what the Data Protection Act is doing to those who support HR functions is just adding another layer of things that they used to do initially in terms of just the confidentiality and the private nature in which they used to handle employee records. So this is an extra layer that will have HR plugging in to various other departments to support its functions. So we are now looking at the compliance and legal team weighing in on how HR will deal with its operations. We are looking at how IT and InfoSec will also plug in and assist HR achieve a level of compliance. We're also looking at a situation where maybe risk may be brought in to plug in and just help HR both sides operations. So HR is slowly going to move from one of those HR is going to move from one of those departments that used to operate in a very dark silo, and it has to be now in the ecosystem of everybody else who's practicing data privacy. So like Mercy said, you have your house girl. What are you trying to protect? And that's what data privacy is about. what measures, what mechanisms, what safeguards are you trying to put in place to protect this house? The first thing is to identify what's in the house before you protect it. Like Anne said, we sit on a lot of employee information that dates way back, way back. What is very apparent is that a lot of people get employed from probably ages 24, 25, and retirement age is probably at 60. So the first thing you need to do is do a data mapping exercise, understand the life cycle of employee data that you hold as an organization. Law firms, most of them are at the 50, very few have reached the 100-year-old threshold. A lot of organizations are between the 20, 50, 75, 100-year threshold. Again, your employees serve you from age 25 to probably 60, 65 when they retire. That should give you an indication that the data sets we hold go through a lifeline of this number of years. And this is the data set we hold for this number of years. The employees who leave the organization, some who pass on during the tenure of the employment, but some who serve you until the end. How many of them serve you to the end? You're able to know those numbers based on your operations of the years. Once you do a data mapping audit, which is just taking stock of this is the information we collect. We collect it at recruitment, we use it for promotions, we use it for placement, we use it for transfers, and we use it for exit interviews, and we hold on to the records in case there's any beneficiaries who come looking for these records, in case there's any tax implications, in case there were any labor issues that were ongoing, and that's why we hold on to this information for this long. Once you identify what assets you have, then you can identify what potential risks you face if there's anything that happens to this data or you continue holding to them. Once you identify the risks you face on the basis of this data, then you're able to put into place organizational or technical safeguards. So the other thing that usually guides a lot of data privacy practices is the 3 Ps. You have the people, you have the processes, and you have the policies. Are your policies up to date? Are they do they align with the law? And where possible, do they align with the best practice in the labor market? Because in this case, we are looking at the Data Protection Act, but we are aligning it to the Employment Act, and we are also aligning it to the HR policy, and we're also aligning it to jurisprudence that's coming out of labor courts. So are you aligning your policies to be able to meet the challenges of the day, like we've discussed? Are your processes seamless in that if there's no policy to dictate what needs to happen at the next step, the SOPs that have been provided for the processes that govern employee data are immaculate, are seamless, and are able to protect the company or the organization? Are your people well trained? Are your people well skilled to be able to fulfill the capacity or to fulfill their undertakings when it comes to handling employee data? Once you have your 3 Ps in place, then you also reduce on the risks or the potential risks that you look at when it comes to handling personal data. Then eventually on technical safeguards, I won't go into details, but there are a lot of tools. There's a lot of cybersecurity tools that you can use out there to basically provide information. Remember, we are talking about personal data. This is information that can identify people. Anything else that is not personal data, you can apply a different level of security. But when it comes to personal data, the Act places a higher threshold on the organizational or technical safeguards that you can put in your organization to just make sure that the employee data is protected, which is like encrypting data that you no longer use, or anonymizing, or just giving access in the same way employee files are kept in that metallic cabinet. When it comes to the digital systems, you also manage who has access to some of these records. Is it payroll? Is it HR? Is it security? Is it admin? Is it CEO's office? Who has access to all these records? Then eventually, like Louisa and Mutia said, you will be disclosing some of these employee records. You are under statutory obligations to disclose some to Central Bank, to KRA, NSSF, NHIF. When you're making these disclosures, employees know you're supposed to make these disclosures. But have you talked them through the process of why it's important to make these disclosures? Some of you, your employees are signed up with circles. In these circles, you have other employees who are guarantors. In most cases, you have defaulters. Letters come, people's names, people's balances, everything is put on that circle letter. It's put on the employee notice board for everybody to see. So what processes are you putting in place to just ensure that this kind of information, as it was then circulated, now has a level of protection in the way that it's going to be circulated? Then, like all the speakers have said, the regulator from time to time should be able to issue guidance or guidelines on how you can better improve your HR policies to align them with data protection policies and guidances. I think I'll stop at that point, Josephine.
Okay, thank you, Janet. That was quite insightful. So I'd like to proceed to the next question, and this goes to Anne. So for Anne, within the recruitment cycle, are there any specific tools or technologies that can help organizations to maintain secure data handling?
Thank you for that, Josephine. I think the main message should be, as much as should move from the manual collection of recruitment and processing of recruitment data to automation. Automation ultimately helps you to achieve data protection compliance. Some of the systems you can consider is an applicant tracking system that is, fitted with all those security measures that Janet has spoken about. You can have firewalls, encryption, anonymization, all within your system. So move from the physical space, or even if you are going to maintain the two systems, or you perhaps because of budgetary constraints cannot afford to perhaps get the applicant tracking system running, what can you do within your existing platforms? For example, if you are Google based, how can you use your drives in a better way to manage your HR data? Or if you're using Microsoft, how can SharePoint help you to achieve that? So some of the technologies you don't have to go outright and buy because of budgetary concerns, but do consider. And a lot of people have seen only fixate on the customer data, and they say there is no budget for the HR data. But if you look at these complaints that are going to the data commissioners, pretty soon the headache will come from the employees and from that space. So you need to be very proactive in making sure there is security around the data. You could also consider secure video conferencing platforms for your interviews. If you're using Zoom and Google, to the highest levels of security that are available on those platforms, some of the considerations that you can put in place.
Okay, thank you for that, Anne. So we proceed to Louisa. So Louisa, we've seen all those scenarios, but what about the event of data breach? What should organizations do to minimize the impact and comply with data protection regulations?
All right. Thanks for your question. So I think it's important for organizations to have a clear incident or breach response plan in place. And then it's very important for you to educate the people then that are going to implement this breach response plan, because the truth is a breach could happen from any point. And if you're sitting in the data protection office or another bit of the business, you may not necessarily be the first touch point that the breach happens with. And we have regulatory timelines for us to report the breaches that will happen. So if you're going to be signing, well, ensure first that you sign data processing agreements with all your data processors. But in addition to that, just ask them or put it in the contract, actually detail it, that they would report a breach to you immediately, or at least within the stipulated time in the Act, at least 48 hours after the breach has happened, to ensure that you as a controller, if it's a notifiable data breach, that you then get to fit within that 72 hours to report to the ODPC. Because the worst thing you want to happen is you'd rather be in control of reporting the breach to the ODPC as opposed to you being on the other side of responding to all the different questions. So I'd rather just put your response together, make sure you have business, if you're going to get internal approvals, and then now forward that to the ODPC as a consolidated response. You're going to be working in conjunction with InfoSec, cybersecurity, whoever in your management team or in a management board, then they need to know that in advance as well. Because what tends to happen is people, one of my colleagues used to say, don't keep quiet, come and talk to me. So ask them to come and speak to you, especially if you're handling data processing and data privacy matters, because at the end of the day, the buck lies with you. And if the organization was to get fined, God forbid, then you'd be the one who'd be handling the back and forth, the reputational risk, etc. And you want to avoid all of that. And then now, over and above all of that, I think it's also important then to notify the affected parties, if you need to, the data subjects that would have been affected by the breach, and also the relevant authorities if it's not just the ODPC, because some of us working in financial institutions also report to other regulators, like Janet had pointed out. So it's the CBK, maybe if you're sitting in the insurance industry, it's IRA, or whoever your regulatory body may be, depending on the industry that you work or sit in. I think it's also important for us to then, even if you're going to be doing a general training in your organization in terms of data protection, for you to have a specified training just on breach response, of what qualifies as a breach, what is a notifiable breach, how should I handle it, all of that. And then ensure that the business, the people that sit in the business, if you have data protection champions, or even if it's just other people in the business, that they understand that there are different details you need to provide to the regulator. So it's not just a breach happened, oops, let's report it. No, you need things like the name and time of the breach, roughly how many data subjects were affected, and all of that. And then if you're going to be releasing anything out into the media, then just make sure that it's proper before it goes out, so that you're not in the position of a certain supermarket, which we know, which released one notice and they were like, oops, we goofed, and then they have to release another notice because that one then complied with everything. Yeah.
Okay, so thank you for that. Thank you for that. Now, if we have any questions, let's post them under the chat section. We'll be able to address them once we're done with the presentation. So I'd like us to move to the next session, which will be dealing with data privacy. So I'd like to invite Mercy to take us through.
All right, thank you so much, Josephine. Okay, so the next question, maybe Janet. I'll tweak this a bit. Yes, we're talking about data privacy through the employee lifecycle. Maybe just tell us, what is the importance of training? I've just noticed so far we've not really brought that out properly. So I'd just like you to address that particular question. Training with regards to data protection.
Whenever I talk to my clients or I engage people, I always emphasize on training, awareness, sensitization, and just upskilling. And I cannot ever emphasize it enough. And the reason is because what we are doing is something that has existed. It's just that it's been operating in a very undefined space. And because it was operating in a very undefined space, it was abused. And it was abused for some time by the tech companies, by the marketing companies, but even those committee guys. Like, there was a lot of abuse in terms of how our personal data is handled from the word go, whether it's at the supermarkets, at your estate, within your organization. And because of that, it requires a change of mindset. Humans are used to, when they know things are done in a particular way, it becomes very hard, especially adults, to tell them that this is the way we are operating. And for you to be able to have effective policies, a good culture, effective processes, then people's mindset must also align to all these things. And how do they align to this? It's not by warning, it's not by putting fancy flyers or by putting nice screensavers on laptops, the way corporates normally do to kind of just spread some sort of awareness campaign, whichever period. Training involves you sitting them in a classroom, whether physically, whether digitally, and hammering these lessons into them continuously. Because today, the data breach is the watchman at the gate. Tomorrow, it's somebody in the IT office. The next day, it's somebody in the finance office. And you're only as good as your weakest employee. There's a current criminal court case that's going on against a mobile network operator, where the employees stole a lot of customer data. And I'm talking about employees who've gone to school. These are not your random committee, run-of-the-mill petty criminals. These are gentlemen who've gone to school, who've studied, and who had worked for a while. And they managed to get access to a lot of customer data. They snuck it out using technology as well, and were selling it on the World Wide Web. And because of lack of proper training, I will not go into the organization safeguard, but lack of proper training, they were not able to appreciate that these are the risks we look at as employee, and this is the risk that our employer faces if the customers get to know the fact that this information has been removed without authorization from the organization. So training is more of adjusting and setting the culture and the mindset of everybody. And it's not only to employees, it's also you in your personal capacity, because you do give data in a personal capacity. So attending training sessions like this helps you question and query, why is my employer asking this? Why is my children's school asking for all this information from me as a parent? Why am I giving all this information every time yet they have it in there? It equips you and it enables you become a better person in terms of just handling your privacy and your personal data, but also being an employee of an organization, understanding what role you play in the entire ecosystem.
Thank you so much, Janet. And actually, just to add, the Computer Misuse and Cybercrimes Act is real. As much as we are discussing data protection and majoring on the Data Protection Act here, the case you're saying, like now the criminal angle of it is pursued under the Computer Misuse and Computer Misuse and Cybercrimes Act. And the penalty, I think, like the biggest, there are fines, obviously 20 million, things like that. But the worst, in my opinion, is 10 years imprisonment. Okay, there's one there on personal culpability. Like personally, you'll go to jail for 10 years of your life wasted for not appreciating the reality of not following data protection practices. Okay, so that's again something to shed light on for your clients as lawyers, but also law firms. Dear law firms, kindly consider personally. Now, the next question is for Anne. Anne, are there any differences in data protection requirements between the recruitment phase and the post-hire phase? So, for example, Mercy Mutinde has been hired by Anne's law firm. You had my data that you collected when I was in the application period. Now I'm an employee. Are there any differences in these requirements? Recruitment phase versus post-hire.
So thank you for that one, Mercy. Actually, the principles of data protection remain the same throughout the life cycle of the employee data. From the moment you pick the data to the last day that you dispose of it, you are supposed to bake in those privacy requirements into each stage. Having said that, though, there are some few things that are applicable when now somebody becomes an employee. And one of them is policy rollout. That once people join you and when they onboard, you need to roll out policies to new employees. For those of you who are going through data protection now, of course, which is many of the organizations, you need to roll out to existing employees. So you need to develop your data protection policy, your incident response plan, your subject rights handling policy, your employee privacy policy, and all the many policies that you want to speak to data protection. The development is one stage, but the rollout is another. And that's where the training that Janet is talking about comes in. Don't just publish policies and expect that your employees will understand them. They are going to be your weakest link. If they don't understand the policies, if you don't train them, you will always be answering complaints at the Office of the Data Commissioner. So make sure you develop the policies. Make sure you centralize, give an access, a central point of access for your policies, be it a portal, be it a drive, somewhere they can go back over and over again to read and understand the policy. I always say, give yourself almost 2 years to get these things hammered into the employees' minds. And this is after 2 years of consistently working with them, because they need to be reminded are new and they're difficult to understand. The second area you need to focus on is confidentiality. It's a big aspect of data protection, and you can secure it when an employee joins you by ensuring that you have standalone confidentiality agreements. I know the practice is that most of us put confidentiality statements in the employment contracts and believe that employees understand them. But when you see what people go and do in their nyamachoma joints talking about things that are going on in the office, it really can give you a panic. So you do need to constantly remind the employees of their data protection obligations through this policy. You need to think about third parties like unions, trade unions, payroll processors, and the like. There is a lot of information sharing that happens with these third parties once employees join, medical service providers. So you need to think about, are they controllers or are they processors? And what is the right kind of agreement you need to have in place with them? Because if it is a controller, then you need to think about data sharing and how you're going to secure and who takes what obligations, who's responsible for what when you share that kind of data. We also are picking consent during employment. One of them is for processing children's data. When you're onboarding children to your medical covers, are you seeking consent? And you do need to seek, because Section 33 doesn't give you like a discretion not to seek consent. Are you seeking consent for employee images, which is another big area of litigation? That's when you get that. Think about staff exits. What is happening when a staff member leaves your organization? Do you have a uniform policy to guide you around staff exits? Because that is where you could lose data. That is where they could copy the payroll and go with it and go and leak it, especially if it's a bad leaver. It's somebody who's leaving when they're disgruntled. What measures do you have in place to secure data? If they're going with your devices, how are you removing the information if it's the laptops or the phones? How do you secure the data at the point of exit so that people don't leave with your information? And finally, which we haven't really talked about, but applies both in recruitment and in employment, is what are you doing about data subject rights requests? How are you handling? Have you put a process in place to make sure that you're meeting those timelines between 7 days and 30 days, those tight timelines we have in the law? How have you facilitated? Many companies are focusing on the customer requests, but if an employee makes a request for their staff file, can you really refuse? You can't. And how then are you going to respond within those timelines? Who is responsible for receiving the request in the HR department? And then who's responsible for responding? And who's keeping the record of who asked for what? So that also is something that must be thought out. So the differences are few, but they are there. And it's just a matter of understanding the processes you do have in your employment phase.
Thank you so much, Anne. That was very, very insightful. The next question is for Louisa. In view of all we've had, could you please provide us with examples of best practice for managing employee data privacy through their tenure within an organization?
Yeah, I think given all that we've heard from Janet and Anne, yourself and Josephine, and my contributions as well, I think some of the best practices would include conducting a privacy impact assessment, which is wider than the DPIA that one of the speakers spoke about, offering ongoing training that Janet and Anne have clearly highlighted, and the importance of why, and maybe even different levels of the training. So a broad one and then a more specific one to deal with specific issues. And then also ensuring secure data handling in employee related processes as well. I think those are some of the best practices and takeaways that the attendees of the webinar can then walk away with from today.
All right, thank you so much, Louisa. The next question goes to Janet. How can employees exercise their data rights, their data, all the data subject access rights, categories within an organization without fear of reprisal? These are rights given in the law. But there shall be consequences. Kwa ground. Saa zingine vitu ni different. So how can employees exercise their rights because they're data subjects? Yeah.
I mean, just to follow up from Louise and Anne, the Act does give timelines for the several data subject rights, the access, stop processing my data, correct my data. I need you to move my data from your organization to the next organization where I'm going to be employed. All those rights have certain timelines within the Act. And remember, the employer is also, where applicable, where necessary, they may charge a reasonable fee for giving, for serving some of these data subject access rights. But also, as much as they are guaranteed in the Constitution as well, some of them might be met with a reasonable explanation as to why this may not be met, or justification as to why some of these rights are not automatic, especially when it comes to like a right to object to some processing activities. If I'm under a legal and regulatory requirement to do it, I'm sorry, I will just not be able to respect certain aspects of your request. But employees, having worked in the organization as opposed to customers, employees fear, there's a fear of, if I ask for this, it might be met with this certain judgment. And it's not a matter of asking for all the information. There's something such as, can I have access to my file, to my personnel file? Why would you need your personnel file all of a sudden and you've been working here for 5 years? And that's the kind of training and that's the kind of organization you need to give these people who are front facing on the employee subject request rights. And some people may not have grounds or may have very flimsy reasons for wanting to see their files. Then you take them to task. You ask them, you want to access your file. Is there anything in particular you want to access your files? Have you lost your CVs? Have you lost your certificates? So that what you want is to access your files to be able to get copies of this. In that case, I don't think you need to access the file, but listen, come peruse it with me. I'll pluck out the necessary certificates and you can make copies of the same for your records. If it's a matter of appraisals were done, I'm not happy with the mark or the comments I got from my appraisal. Am I able to, I don't like the general feedback I get. Can I access my file? Can I access my records so that I go into the detailed scoring so that I'm able to see what my immediate supervisor gave us feedback? You have to remember that as much as it's data privacy and data compliance, it's also a governance issue within most organizations. And with governance, there are resources or there are mechanisms where employees should feel free to articulate the concerns they have with as they exist in the organization. In the same way, there's whistleblowing that's been provided for. So you should be able to provide channels within which employees should be able to put in their request rights, whether you want it done anonymously, whether it needs to be done in person, whether you can leverage on tools that employees can ticket and ask, this is the kind of information I need, this is the specific information I need, and this is the reason I need it for. Then the teams responding to this request are able to cushion or to come up with a reply that is appropriate, that is legally sound, and that also complies with that respects the data subject rights of this particular employee. And it's quite a tricky balance because personnel file are considered very private, and you will get cases, let's say it's a staff disciplinary issue. Witness statements have been collected. This employee is bullying that employee. It happened at the reception. 5 other employees saw it and it became a disciplinary issue and they all recorded statements. And this employee is being taken to task to report, to give their side of the story. So if they do ask for any information relating to them or any information identifying them during this discourse, it's very easy for the organization to say natural justice is entitled to know what his accusers are saying. But what we may do is redact the name of the witnesses for purposes of protecting the investigation or keeping the investigation private until you're able to reach a conclusion. There are other cases where, let's say, if it's a criminal record that was procured from background checks through third parties, and it ended up being a matter that was in court. Again, those are situations where you can disclose to the employee and tell them this is actually a public record procured from public sources, and as such, we don't have a reason disclosing it to you. But if it was procured through private means, there are certain aspects you can leave out that do not necessarily interfere with the integrity of the report and pass it on to the employee. It depends. It will now depend. There's no formula. There's no standard guideline provided for in the regulations and that, but it's more of a case-by-case scenario of the organization. It will be a matter of balancing the employee data subject rights, but also balancing the integrity, the privacy, and the confidentiality of some of the information that is being stored regarding this employee or other employees in the organization.
Thank you so much, Janet. That is so insightful for lawyers here who will be advising their clients in those situations. You now have all your metrics to help them think through. But yeah, the classical legal answer, it depends. So you ascertain what are the realities of the case, and then now you're able to apply the principles. Thank you so much, Janet. The next question is for Anne. Maybe you can tell us what are some emerging trends or challenges in data protection related to recruitment and employee data management?
So I think Some of them are already presenting themselves, as we see in the complaints that are coming to the data commissioner. What is permissible when you're doing a background search? Just, should I get consent? Should I, what do you call it? Should I go deep? Can I go into social media? So I think there, that is one of the emerging areas. Background searches are one of the areas. The main thing you should do, in addition to maybe seeking consent, because that is the guidance we are getting right now from the data commissioner, you can also do a background search policy, an internal one that informs you as a company what is permissible for you, which you can do after you do your impact assessment, and you can tell why you would need certain levels of searches for the kind of organization you are. A big area that is emerging is that data protection is being used as a new avenue for bringing employment claims. So, and it's worldwide, it's just not here in Kenya. So now employees know there is I need my investigation report perhaps. I know there's been debate about whether you can release, what you can release, how much information, but do not be surprised if an access request leads to either they're going to use it to defend themselves in a disciplinary case, or it's going to be used in court. So that again means you have to be very careful when you're responding to an access request. You have to make sure that whatever data you're giving is accurate. You have to make sure it's up to date, because it could lead to a roundabout claim that perhaps you couldn't have foreseen. So we have, I think I have seen a number of cases in the UK, most specifically around how employees are using data protection to be able to, as ammunition for a disciplinary hearing. Next area is around remote working from home, and data protection in that context, especially in terms of systems. How are you able to control access? I think many organizations, the big organizations, it's easy because many of them have VPNs, they have secure firewalls, they have thought it through. But for the smaller organizations, working from home is a real headache. People taking laptops, being able to access information remotely, downloading it, and then it is then gets lost in that scenario. So really thinking through what is permissible from a working from home scenario. Another big area that is emerging is employee monitoring. Can you monitor the activities of your employees on their devices? What is permissible and what is not permissible is again a area of litigation. Can you find an employee going to a personal sites during a lunch hour, searching for an engagement ring, and say that they are misusing your devices? What is permissible again goes back to transparency. If you have to monitor employees, you must be transparent in your policies about the fact that the monitoring will go on, and you have to also mention the type of monitoring that will happen. So again, monitoring secretly is a data protection violation. Even if the devices are yours and you are the owners, please let's ensure we have transparency. Using and social media checks are another area of challenge that are emerging. Can you rely on social media checks to initiate disciplinary action, or can you use it to deny somebody a job? Again, goes back to transparency, but also goes back to data minimization. How relevant is that social media check to your to the job or to the actual processing activity that you're carrying out? Does it tie in, as we said, in other areas of employment? There is now the right of the employee to do what? To switch off after 5 p.m. and up onto Monday. So can you really hold them accountable for things that they have done during those hours? So those are emerging areas or emerging challenges that are coming up in the employment space. All I can say is that this is just another way for employees to lodge claims, to make the employment court busy. I believe in addition to the data commissioner's office. And so for employers, it's all about your policies and your processes. They will be tested when you go to court against the principles. So maybe one thing I can mention is if you can map your recruitment and HR processes to those principles of data protection, If you can tick every process against every principle and just show and demonstrate what you have put in place against them, you're there, you're almost there in compliance. But if you cannot say, specific to a specific area principle, what you're doing in your organization to make sure that you're covered, then you are definitely heading towards the non-compliance space.
Thank you so much, Anne. Uh, yeah, very interesting food for thought. So, thank you so much for all the insights that you've really pointed out. And those are really the things that we're going to be seeing in the litigation and in the complaints to the Commissioner's office. So, the next question goes to Luisa. So, it's a bit lengthy, so we'll split it between Luisa and Anne. But the question is, does psychometric data collecting during the recruitment cycle fall under sensitive personal data? And if so, what lawful basis should HR rely on when processing it? Okay, that's for Luisa. And then Anne will come in to answer if they can rely on more than one legal basis or not, because that's like a whole CPD on its own. But yes, Luisa, maybe just start us off with this psychometric data. Does it fall under sensitive data? And what are options for legal basis that HR can rely on?
All right. Yeah, happy to take the first part of the question. So the actual choice of legal basis will depend on the organization. The purpose for processing, the context and relationship with individuals, and some options are available. So you can either go with consent, legitimate interest, or a legal obligation. So if you're speaking about consent, it would be whether the company can collect and process the psychometric data with the explicit and informed consent of the candidates. However, this consent should be freely given, specific, and revocable at any time. It's also important to note that if you're relying on consent as a legal basis, then that consent can be withdrawn at any time, which a lot of people are not very aware of. Legitimate interest. The company may rely on the legitimate interest as a legal basis for processing the sensitive personal data, including psychometric data. If there's a legitimate and compelling reason for doing so, the company must conduct a legitimate interest assessment to balance their interest against the rights and freedoms of the candidates, and only rely on this basis if the results of a legitimate interest assessment allow for such use. And then the last one would be the legal obligation. So if there are any legal obligations require the processing of such data, for example, like industry-specific regulations, then the relevant company can rely on this legal basis, but the specific legal provision or regulation must be cited as a basis for the tests. And I think it's also important to point out that whatever the case, each company must have a privacy notice for the applicants and or employees that speaks to the collection of personal data as used in the recruitment or employment process. And if the psychometric data is collected, then the notice must explain the nature of the information that's collected, the legal basis for the collection, the rights of the data subject and how they can be exercised, and all other things required by the law to be stipulated in the notice, including the retention period that has been pointed out before. And should the data subjects request copies of the test and results, then they have a right to get them under the subject access right request, which we've mentioned before, provided for in law, and the company must comply with a strict statutory time frame that's then stipulated for that. I think it's important if you're going to administer any psychometric tests, as Anne and Janet had pointed out, that you ensure that the candidates understand exactly what information of theirs is going to be processed, and that they have a right to receive a copy of that psychometric test and the results, etc. And maybe even what sort of way or weight it's going to then have in your recruitment process if you want to then rely on it on a yes or a no in terms of picking the candidate. I think I'll hand it back to Mercy for Anne to answer the second part of the question.
Thank you so much, Louisa. And yes, food for thought. There was also a question on the chat about psychometrics, so we've also covered your concerns there. But now, Anne, can such companies rely on more than one legal basis? You see, Louisa has given options for consideration, so you let us know. Do you have to pick one, or can you put all of them and let the people figure out which one?
Yeah. So of course, I think putting all of them and leaving people to figure out means that you also are guessing, and you also don't have a good idea about what is going on. So what you need to do is you do need to do that inventory and mapping process where you identify the types of data you collect, and then you have to then justify, assign purposes to each of those types of data that you're collecting, and then finally you then decide based on the purposes and the types of data, what is the most logical, what do I call it, lawful basis to assign. So for example, if the information is photographs, staff photographs, and you will assign purposes to be maybe identification, or maybe you assign a purpose like marketing and branding. If you put marketing and branding, of course, the only lawful basis that you can have is consent, because that's what the law says, that you can only process marketing data on the basis of consent. So for that reason, then you cannot assign all the lawful basis, because it will look like you did not understand that for photographs, the types of lawful basis that would apply would be consent. The same logic then applies for every type of data, that you can choose the lawful basis, and there can be many in a scenario, but they must be justifiable. You must be able to show that would be the basis I'm picking. So for example, if I was to think about what is the lawful basis for picking employee data, and one of them is maybe teachers' data. There's actually a very recent case in the Data Commissioner's database of cases by the Aga Khan Hospital, where they were seeking for data. They were doing a reference check from a former employer, and they asked for the payslip. And then they discovered that the payslip had been falsified. Whatever the employee had given and whatever the former employer had were different. Yeah, and so the lawful basis there were multiple. There was one was contract, which is what you're seeking to do. You're seeking to enter into a contract with a person, and the other was public interest. That there is public interest in trying to make sure that the caliber of people you're hiring in your organization are not going to be people who are dodgy. So you can have multiple, to answer the question, you can have multiple, what do I call it, basis, but you have to apply logic to it. There has to be a way in which you arrived at that lawful basis. And mostly it's the mapping and the inventory that leads you to the lawful basis, which must also be declared in your privacy policy. I have seen in the UK, they have gone a step further to say, actually, when you're writing in your privacy policy, the types of data you collect, you have to state the types of data, you have to state the purposes. It's like 3 columns. And then right next to it, you have to state your lawful basis. So kind of like you're importing your DPIA into your privacy notices to meet the requirement, as opposed to just giving a laundry list of the lawful basis.
Wow, thank you so much, Anne. And yes, that is true. Actually, you get it right the first time. And even this question has come up a few times at the forums with the ODPC. And the office was also clear. It shares similar sentiments about get it right the first time. Once you pick a legal basis, you can't say you are doing this based on consent today, and then tomorrow you come and say legitimate interest. No, 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 no. That's not how it works. You do your DPIA or your PIA said by Anne. You ascertain based on the grounds, the facts, the scenario, which is the most suitable ground. And that is what you publish in your privacy notice. And that is what you die with. Because once there's an issue, for example, that goes to the commissioner's office, she's going to look at what was stated or what was disclosed to the data subject. So if you disclosed consent, you then you go and tell her legitimate business interest or something else, they will not take that story. Yeah, because that is what it will be at that point. It will be a story because what you disclosed was very different. All right, thank you. So now maybe from I think the panelists, you can give us your final thoughts from the conversations that we've had. So we'll begin with Janet, and then Louisa, and then Anne. And then we'll call in Josephine to help us tackle the Q&As from the chats.
Yeah, my closing thoughts. So a bit of history. The European Union enacted and came up with the General Data Protection Regulations. This was sometime in 2016, and they gave most entities a 2-year moratorium period to just get their house and their orders in affair before the actual enforcement and implementation of the act in 2018. In Kenya, we implemented our act, we enacted the data protection after various false starts around 2019. The regulator herself, Mrs. Kasait, was appointed sometime in 2020, and her office started taking shape around last year, this year. So they are still, as much as they are enforcing, they are still operating on a learning curve in terms of all the sectors, just coming up with very specific industry-driven guidelines and all that. So we are looking at 2016, if we are going by best practice international, to 2023, if we are looking at a local level, and people are still grappling with compliance. So compliance is not a 1-month situation. It's not a 6-month situation. It's not a 1-year situation. And when you look even at our Data Protection Act and regulations, you're supposed to go for your license after every 2 years. And just with most regulators, when you go for your license, you're supposed to file some sort of returns for the regulator to see whether the status quo is still the same or not. And the truth of the matter is, wherever you were in January this year in terms of your staff intake, in terms of your employee rewards, in terms of your third-party engagements, as far as your employees are concerned, they've changed. You probably are not using the same security company, you're not using the same payroll company. You've added an extra set of processing employee data. You've onboarded other employees. You've added a lawful basis for processing new aspects of data. So these are things that change as the year go by and as months go by. And that's why now the regulator is saying every time you go for a new license as a controller, we need to see your record or your processing inventory or your record of processing activities. So what does that mean for you as an organization? You go back and you audit yourself and you map out your data. Are we still collecting people's location in the village? Why are we collecting it? Is it unnecessary data? Can we scrap it away in time for the fresh filing? We are a financial institution. We are required to collect this kind of information. It's important. You also, the Wells Fargo situation where people have disappeared with money. The investigation usually begins from somebody's village. It is important that that data is on record. For law firms, it is not so important that certain data aspects be on record. So as you're complying, as you're helping your clients comply on an annual basis, on a biannual basis, what you're doing with them is going through their data sets, their processing activities, their lawful basis, their organizational and technical safeguards, and telling them this is now outdated. Can we get with the new program? This is now outdated. This is a risk. Can we get with the new program? And there's money to be made. I'm not even lying to you guys. There's money to be made. There's a lot of opportunities within the data privacy space, dispute resolution, advisory, drafting. There's a lot of to be done. So you just need to find your place, help your clients find their place, and just help them with their compliance journey, because it doesn't stop. It's a continuous, ever continuous process.
Thank you,
Thanks, Pastor.
Janet. Yes, there's also money to be made in training people. Okay, and like Janet has said, and the best way to prepare is to do it in your own operations. So, dear law firms, please implement for yourself first, for your steep learning curve, so you learn and you know what is theoretical versus what is practical, pragmatic advice. What part of the learning curve you like. You decide, me, I like doing DPIAs, we shall do them. Or me, I just want to do training. Or me, I just want to do advisory. Those are things you'll only discover as you dip your hands and your feet in this. And the best place to do it is with your own yourself. Okay. So then when you're going to offer and offering to a client, you have some experience, even if it is of yourself, it is important. So thank you so much, Janet. I've gotten a request for you to please post on the chat what the 3 P's were. That was a hit with people. So you can type for them in the chat so they can see. Thank you. Louisa, over to you.
All right. I just want to agree with what Janet and yourself have said. I think what I always tell business, because they always come and say, so who's in charge of compliance? And can you comply 100%? And our answer is, I see Mercy is laughing, compliance is a journey. So you'll never be 100% compliant. You have to work with everyone. And I think that just speaks to my next point of, if you're working, so I'll speak on it from the business side. I won't really talk about it in terms of the law firms. So from the business, I think it's important to have everybody's buy-in. Make sure that everybody understands what needs to be done. I mean, it's great when fines are issued by the ODPC. I say that because then they run to your office and they're like, gosh, what these people do is super important, so we need to comply. But I think it's important for us to understand that data protection is not a one-woman or a one-man show. It's everybody. Everybody needs to pitch in. So if you're handling data with third parties, you need to make sure you have a third party management program in place. You need to have board buy-in. You need to have business buy-in. You'll also find yourself walking around and speaking to a lot of people. So you tend to be very many people's friends, and sometimes not their friend, but you still need to do their job and yours as well, to ensure that they understand what you're talking about, because data protection sounds like a lot of Greek. And then don't put things in a lot of legalese if you have a legal background. I see Thomas is also clapping. And then also have buy-in. From people like InfoSec. InfoSec stands for Information Security. I realized we're using that term and didn't define it. But also make sure you have buy-in from the different partners that you're going to be working with. So your cybersecurity team, your InfoSec team, from board, from business, from data protection, if you're going to be outsourcing with the legal law firms, all of it, so that you're all speaking the same speak. And then make sure you understand exactly what your legal and regulatory obligations are, and especially the timelines, because those will come and bite you. And then if you're going to be doing something like a DPIA with your business, take the extra time to explain to them what a DPIA is, and then keep hammering the fact that it needs to be filed with the regulator 60 business days before you go live, so that they don't integrate you at the last part of the process. And then they're running to say, oh my gosh, we don't even have internal approvals. We don't understand what this DPIA thing. And then you guys are just delaying our timelines. No, we're not. We're just trying to help ourselves and the company comply. And then also, I think it's important for, if you're going to be instituting something like a ROPA, which Janet had mentioned, which is the Register of Processing Activities, that the business understands what a ROPA is, that you also then take time to the business understand what their processes are, so you're able to do things like data mapping and give feedback. Because if you in the data protection office understand what business does, then one, it's easier because you build a rapport with them, but two, it's also easier for you to advise if a project is going live. You know exactly what is being launched and why, and how that can impact the company. And then it also makes you look great, because now you know what's going on in business, so everybody smiles with you. Yeah, so I think those are my parting shots.
Thank you, Louisa.
Yeah.
Yeah, and though I think you are speaking more from an in-house counsel perspective, for the benefit of the in-house counsels attending here, everything you said is still very applicable to external counsel who are supporting businesses in their privacy impact assessment or supporting them to do implementation. As external counsel, please make sure you have buy-in from all the stakeholders. In fact, the first agenda, let me just give you a pro tip if you ever have a data privacy assignment, is to ask for an interdisciplinary committee that you will be working with, okay, for the implementation. That's like the proest tip here, so that you make sure you at least have access to main functions and the business functions. Otherwise, as external counsel trying to support, your work will go nowhere for lack of buy-in. So everything she said still applies to external counsel. The only difference is you're doing it from external counsel angle, okay? Yeah, because some organizations will come to you reaching for help as external counsel, mainly because they don't have an in-house counsel. So all the things she's described there will be part of the work you're doing and billing for. So it's very important for you to keep that in mind. Thank you so much, Louisa. Over to you, Anne, please.
I think for my parting shot, I will emphasize on just because this is a lawyers forum, just really understanding this law and reading it really high, and because we are the ones who are setting the jurisprudence that is going into the complaints and into the courts, and there's a lot of room to challenge a lot of the things that are being said and that the way things are working. So just a very deep understanding of the law will really go far in also protecting your clients and protecting yourselves. Don't just take the ODPC decisions as the final. There could be appeals and counter appeals that come from those processes. See how you can challenge, and we can get the best jurisprudence from this very new area of law and area of practice. I will also recommend the trainings. Please just invest in training your employees. I say the employees are always going to be the weakest link. They are the ones who are going to implement these background searches. They are the ones who are going to keep the CVs for many years, the ones who are definitely going to expose you to a breach. So you want to just make them your allies more than you're making them, you're criminalizing them. So don't go for the stick. Really just work on them understanding the act, because once they understand it, they will support your compliance programs.
Thank you so much, Anne. Thank you so much. And now we'll just go to Q&A for the questions that had been submitted on the chat. Yeah, just to then we can call it a day because we are running short on time. Okay, so the first question from the chat was asked by Joshua. It says, talking about technologies, kindly address the use of cloud-based tools like Google Workspace and their implication on cross-border data transfer threshold in the Data Protection Act. So I will just take that question. When it comes to cloud-based tools like Google Workspace, as well as, maybe if you're on the Microsoft 365 OneDrive environment or whatever other equivalent, use of AWS or whatever your other cloud-based provider is, this definitely has implications for cross-border data transfers under the Data Protection Act, as well as the regulations. Now, when using these services, then definitely personal data is more likely going to be processed and stored on servers located in different countries, and this could potentially lead to international data transfers. Now, the reason I use the word potential here is because it really depends on who your supplier is and what their setup is in Kenya. For example, we know AWS has some edge points here in Kenya. So if you're on AWS, how are you accessing it? Where exactly is your data stored? This may vary for different people. And even for the Google, the Microsoft, all of that, again, they have data centers across the world. Where exactly your data sits, you as the team that is using it, you can be ascertained by your IT department, or your supplier, whoever is reselling the Google Workspace licensing or the Microsoft licensing to you. They can be able to help you understand exactly which server of Microsoft or Google or AWS does your data sit on, and that will give you a good understanding of then which countries is there cross border data transfer. You'll get a clear yes or no, and if yes, which countries. Because if your data sits in North Europe, for example, then your cross-border data transfer disclosure is very different from someone who's maybe using the servers in South Africa or the servers in the United States. And the reason why this is relevant, again, to get this information from your IT department or your reseller of these services is because when registering with the Data Commissioner's Office, you are required to disclose cross-border data transfers and the specific countries in the world that this information goes to. So that is where you'll get the data to disclose there. Now, some key considerations for the use of cloud-based services. Now, generally, if you look at the regulations as well as the Act, cross-border data transfer is not outlawed. It just has several conditions that must be complied with for that to happen. Now, first of all, there are sectors that are listed in the regulations as sectors that are required to keep all their data locally. And the word in the regulation is actually they're required to keep a local serving copy of their information in Kenya. So again, this can be complied with depending on who you're using. Is it Google? Is it Microsoft? Is it AWS? US, and what offerings do they have to help you meet this obligation for local serving copy. Now, definitely during stakeholder engagement, all the big tech cloud service providers did engagements with the commissioner's office, and their solutions, they do have solutions that help you be compliant with the local serving copy in case you fall into the industries that are listed in the act. That's like, for example, financial services, national security, anyone who's involved in gambling, betting, things like that, health services. There's a list there. You can always go and look at it to ascertain whether you fall in there. But now, as you're using these cloud services, always remember you are the data controller and your cloud service provider is your processor. Now, most of them are very elaborate and actually more compliant than most of the controllers when it comes to data protection, because they are regulated globally. So generally, the standards in terms of the controls, their data centers compliance with data protection requirements, and even ISO certification. Most of them are very compliant. At least all the big cloud service providers are. But something else also to remember is you need to ensure that you comply with the requirements for cross-border data transfers, which in our case of Kenya, you are actually required as a data controller to ensure that the country your information goes to has adequate data protection in that country. So either they have laws that are similar to Kenya or adequate, that is actually the word used in the legislation. As of now, we don't have any adequacy decision that has come from the commissioner's office. We also don't have a whitelist as of now from the commissioner's office for countries that are considered adequate. However, the regulations do say any country that is party to Malabo Convention is adequate. So that is a question you'd ask yourself from what you've gotten from your IT department and the countries that this information is being stored in. Is it adequate or not? If you're not clear or not sure, or you want to clarify, you can always write to the commissioner's office, compliance@odpc.go.ke, and they will advise you. You can put in a request that you want to know if XYZ countries are considered adequate. They will respond to you. That's more of like a private ruling for your information. But when registering, please, for the love of yourself and your company, make sure you disclose the countries you're in, because then when you disclose, if the ODPC does not come back to you with questions or queries or problems, then you have disclosed it. In case of an issue, if you said you're transferring information to the US and there's an issue in the US, when you're reporting the breach, saying the breach occurred because of an issue in the US, they are not surprised because you had disclosed that your information goes to the US. Now, obviously, some of the other things to consider when doing cross-border data transfers is use of, if the country maybe does not fall in, the adequacy list or jurisdiction, then the other provisions in the law provide for standard contractual clauses. This can be explored, as well as binding corporate rules. This would apply to multinationals or organizations where there's a group of companies involved. Our ODPC office has actually received applications on binding corporate rules, because once you draft them, you need to file them with the authority, so then they are able to review them and tell you if your binding corporate rules are adequate or not. They have actually received such applications and have worked through processing it and working with companies to ensure binding corporate rules are adequate as required under the law. Another thing to also think through is consent and transparency. Please make sure that you are very transparent to the relevant data subjects that their information is being transferred abroad and to which specific countries. Again, if there's an issue in the US, people should not be shocked that the issue in the US is affecting their data in Kenya. This is something you need to have disclosed in your privacy notice. This applies whether for employee, applicant, or even customer. And of course, always make sure you do a data protection impact assessment as you're onboarding your cloud-based tools or processes or services, especially if you're using them to process sensitive information. And think through liability and accountability vis-a-vis your service providers and cooperation mechanisms for any notification and reporting that may be required in case of a breach or an incident. I hope that helps address that question comprehensively. Now, the next question we received was asked by Joyce, and this one I'll address it and will kindly address the issue on candidate application data, such as recorded video interviews stored on servers outside the Kenyan territory. How does one proceed, Anne?
Yeah, so I think you've actually alluded to that in response. You talk about the safeguard, about the adequate safeguards. I think the number one thing you must do when you're doing a data transfer is just look at the adequacy of your safeguards. How adequate are your technical safeguards? How possible is it for you to be breached? And one of the things that you could also do, in addition to the things that Mercy has talked about, is you do need to engage IT, what could I call them, services around audits and vulnerability tests, to just look at the weaknesses in your systems and just understand where are the possible places you could be hit, and then try to put measures to safeguard, because treat it just like any other customer data. Even that could lead to a fine, and even that could lead to a breach. So you can continue, we are saying you can transfer the data, but do what Mercy has recommended. Make sure that you know the countries where you're transferring to. As an extra step gap, you can also consult with the Data Commissioner's Office on whether that is a recognized country for adequacy. And then finally, most importantly, the adequacy of your security measures. Vet your security measures at least once a year.
Agreed, very important. The next question came from Michelle, and this one Louisa will address it. If the data controller is outsourcing their payroll services, should the data subject access request be addressed to the data processor or the data controller? Louisa, the golden question.
Interesting. Hope I'll give a golden answer. So in most situations, you'll tend to find, well, in Kenya at least, in other jurisdictions it's different, the onus would lie with the data controller. So even if a breach or something would happen with the data processor, the ultimate liability would be on the data controller. So if a data subject wants to have a DSAR or institute it, then ultimately it would be the data controller that has a responsibility to ensure that it's actioned. But also I think it's very important for you to realize and articulate who exactly would be data controller and who would be data processor in the situation, and then build into your data processing or data sharing agreement exactly what you would need to do, an escalation matrix for data subject access right to be actioned, because you don't want it not to be actioned and then you're the one who's liable and maybe you were never made aware of the request in the first place. Yeah.
Yep, exactly. That one, make sure you hedge with your agreements. If your processor fails to do what they should do, then you will be fined. You will pay the fine to the ODPC, and then you go and recover contractually from your processor. Just make sure you hedge yourself. Thank you, Louisa. The next question is for Janet. This was asked by Eric. Do you agree fully with the ruling by ODPC on the Faulu matter? I find the determination quite problematic. That is Eric. So Janet, since you're the one who told us about it.
One thing that I also try to sensitize people on is that the ODPC, as their mandate within the Act, is strictly supposed to be on matters relating to handling and processing of personal data and personal information. And they usually limit their scope of judgment. They strictly limit their scope of judgment to, is there personally identifiable information involved? Were the principles of data processing followed? Were the regulations, were the various clauses they provided, were they followed that occasioned, were they followed or were they not followed that occasion to this complaint? And we've seen instances where some of the parties aggrieved or some of the issues brought for determination between the ODPC straddle different legislative provisions. So, and I've seen a question down the line. Some of them straddle copyright and image rights. Some of them straddle vanilla employment in the case of a recent law firm. Some of them straddle employment and labor issues. And the work of the ODPC as a regulator and as the first instant of what would consider a tribunal is strictly on personally identifiable information that was handled contrary to the provisions of the Act. Anything else arising from that complaint or the dispute can be addressed in other forums or other tribunals. So there's nothing stopping somebody from taking the decision of the ODPC insofar as procedural flow or procedural proprietary on PII was followed and using it in a civil matter in a different court or a different tribunal. In this case, It's not whether I fully disagree or agree with the ODPC, but the ruling she gave or the ruling that the office of the ODPC gave can be subjected to an appeal. It doesn't need to stop there. But on the aspects only touching on whether she pronounced herself on issues of PII and also on issues relating to her conduct in terms of the procedure outlined in the regulations and the act of the ODPC in handling disputes and complaints, whether she followed the due procedure. So that can be subject to judicial review or can be taken to another court altogether as an appeal process or as a fresh suit altogether.
Yeah, thank you. But in the interim, what she decided remains a guidance note. And
Exactly.
should you do the contrary, if it
You
has
will
not
end
been
up there.
overturned, yeah, you will be in trouble. So whether you personally agree or not, it's time for implementation.
Yeah.
And that is what implementation looks like for now.
Yeah.
Thank you, Janet. All right, the next question is for Anne. This was asked by Lois. She's asking you to clarify how should organizations handle data from candidates who are interviewed but not hired? This can be a whole CPD on its own, so maybe Anne just condense. Of course, we've said a lot of things here. What are some of the key things in a minute or two?
Yeah, so I think the key thing there is, again, even if they're not hired, remember they could also still pursue a claim, like the Faulu instance, they were not hired. Just define retention limits for unhired candidates in your retention policy and follow your policy. A basic guideline is the 3-year limit for employee cases of employment-related claims. Could be a good guidance, but there are other factors that you may need to consider, but that would be a good guidance.
Thank you so much. Next question. Okay, maybe Janet, bringing you back. Doris has asked, hello, some employers are asking for pay slips and or information on salaries. Is this something that should be encouraged considering the principles of data protection? 1 minute.
I mean, like I said, there are those which are considered the way business was being done, normal practices that were being done. And you'll realize before the Data Protection Act, prospective employers would always ask you for the pay slips in order to know whether to match up or to basically increase your pay. And this was something they asked you and you volunteered the information. So going forward, then I think what needs to be clear in that recruitment privacy notice or application privacy notice, then they need to be inbuilt consents where you tell them at some point we may ask for this information from third party, from credit reference bureaus, and from this. Do you give us your express consent to be able to collect this information and us? And at some point, we may need further and better particulars from you, especially if you're shortlisted, to be able to place you within organization. Once they give you the lawful basis on which they're relying on to ask you for this information, and you voluntarily give it to them within the parameters they've told you will only use it to assess your placement and your salary scale, then you voluntarily give it, it's within practice and it's within the parameters. Those who are asking for it without explaining why, how, when, and where, those are the ones you need to have a problem with, and that's what we are trying to change going forward. If they ask you for this payslip, then you should be able to tell them how, why, when, there, and if you're done, can I get it back? Can you destroy it? And all those things. So that's the tools we are trying to equip you with going forward. But for now, I agree, employers should be able to explain to you the how, why, when, there, and when will we destroy it, to be able to just give you that confidence in surrendering such personal information about you.
Thank you so much, Janet. The only thing I'd add there is also best practice is globally, do not ask for payslip information from all applicants. Only ask for it with the people or the person actually you've shortlisted to give an offer. So if you receive 1,000 CVs, you do not start asking all the 1,000 of them to send you the payslip information. You go through the interview, the recruitment, all of those things, because recruitment is not witch hunting for current pay in the market, okay? If you want to know current pay in the market, get a HR firm to do for you a survey, and they can give you those statistics, because in any case, they are constantly recruiting for people, okay? But you do your 1,000 candidates, you sift them through everything. Once you are clear, you want to give the job offer to Mercy Mutindi or to Janet. If you have one role and it's for Mercy, then it's only Mercy you ask. If you have two roles and you've shortlisted Mercy and Janet, then that is the point at which you ask before giving the offer letter, because the assumption is you would be using the information to determine what offer you're giving. But if, yeah, again, then you'd be able to explain the when, the how, the where, and all of that. But you really have no basis to be sitting around with payslip information for 1,000 people and you're only offering one person the job. Now, that is in conflict with the principles of data protection and particularly data minimization. So that is now, again, best practice to think through for that one. Then the next question. There's a question that was asked by Phyllis, and I'll just combine these two for Luisa. You can take them. What are the data protection obligations on employers in cases of unsolicited job applications? And the next is, in case of headhunting, at what point does the employer seek data processing consent? Luisa?
All right, so I'll answer the second question first. I think it's important for you to just seek consent at the beginning of the process, so that whatever information you're asking for, you ensure that if you're using consent as a legal basis for processing, that you have it beforehand. And then also, I'll just like to reiterate, in your data processing agreement with your headhunter or the recruitment company, just make sure you articulate every single thing that needs to be done, so that you cover yourself, and also ensure that the recruitment company fully understands their rights and obligations in terms of data protection, whether they're going to be both controller and processor or only processing on your behalf. And then the second one, I think, if you wouldn't mind repeating the first question, Mercy, please.
That's okay. It says, what are the data protection obligations on employers in cases of unsolicited job applications?
Okay.
Is it the same as when they solicit, or is it different? Do they get a free pass because it was unsolicited?
I don't think they would get a free pass because it's unsolicited, because there would be PII in some of the information they would share with you. Maybe they'll just send to a random email or your info email, you get their CVs and other things. So maybe as you're responding back, just share with them your privacy notice and then say thanks for the interest in the company, all those good things. And then maybe put like a portal to your career page and then say you can apply here. And when they apply there, then you follow the data processing procedures and policies within your company and organizations. So no free pass, sorry, but just make sure you comply. Yeah.
All right. And Luisa, before you go, there's one more for you here from Diana. She asked, how does an employer balance between data protection rights versus copyright? I know you mentioned an IP, so
Yes.
please take it away.
Okay, so that's a very interesting question. I think even as Anne and Janet had pointed out before, if you're going to be using your employees' photographs for marketing purposes or other purposes, it's important to obtain their consent. Also, if you're going to be streaming live your corporate videos, which is very lovely for you, but make sure you obtain consent. But also, I think it's, yes, copyright, because Mercy's laughing. Well, copyright because, I mean, my face is my face. I can never have another face. It's very pretty. Thank you very much. But I also have image rights in my face, well, associated with my face, etc. So if you're going to have a model release contracts, which some of the corporates do when they take pictures of their clients or customers, etc., at their corporate events over and above maybe getting a lanyard or a band saying I consent to take the photos, then make sure you properly cover the intellectual property and the copyright aspects of that in the photo. I don't think you can say that just because someone has consented to allow you to put their lovely face on LinkedIn and your other social media sites, that then it gives you like the right to resell, or you then use their photo for other marketing purposes and things like that. So that's a bit tricky. So simply because someone has given you consent, then make sure you stick to the purpose limitation of exactly what that consent is for, and don't go outside of the law. If you would like any more information, that will cost you a consultancy fee.
Thank you, Luisa. Yeah, she has a master's in IP, so that's why I threw the question to her. Then the next question, Janet, this one was asked specifically to you by Edith. It says, to Janet, what if a law firm sends pleadings regarding a case involving the staff of a company, and instead of using the email of the in-house legal counsel who has been involved in that case from the onset, they decide to use the general corporate email of the organization? And this ends up exposing this staff's personal business to many staff who had no idea the case was ongoing against this staff. Is there a data breach in this case? Janet, this question is very specific with very specific facts. To pen a number.
It feels like this feels like I'm asking for a friend.
Yes.
It's very real. Um, I mean, we do have the Civil Procedure Code, we do have the Advocates Act, and those have always governed advocates and law firms in how they deal with pleadings and how they deal with fellow, just process serving, and how it ought to be done. If it's a personal matter, I don't understand why you'd need to serve it in a corporate sort of setting. I wouldn't consider it a data breach because in most cases, like Mercy and Louise have said before, when it comes, and Mutia said, when it comes to data breaches, there's a certain matrix, a certain risk matrix that you look at and subject the facts to be able to ascertain whether there was indeed a data breach. In this case, one of the things that the regulator, if this matter was taken before the regulator, one of the things that the regulator would address themselves to is whether there was any sort of relationship owing between the two of you that would amount to a controller processor type. And in such a case, what were the minimum obligations they owed to you and not? That notwithstanding, you are entitled to privacy of your information. Was there any sort of malice and procedural manner in which these pleadings were served to the general email? So what normally the ODPC does is to issue some sort of enforcement notice. And the enforcement notice is to just tell this law firm what you did was wrong. And because what you did was wrong, we need to see this. We need to see you take it down. We need to see you put this in place. We need to see this policy. We need to see you a retraction. We need to see some sort of apology and all those things to show that now that they did the mistake, they are on the track to rectifying it. So it won't be more of them penalizing them immediately without them being heard. It will be more of them telling them, we've received this complaint. Can we see your sort of defense to this complaint? And the regulator will make a decision, just like any court, to see whether there was any negligence, malice, and there was just outright not following the Data Protection Act and them not following what was owed to you, probably as a data subject, and them having some sort of data processing relationship with you. If all those things are not constant, then the regulator is able to make an informed decision after hearing both parties. But I wouldn't outrightly. I know Kenyans are becoming very litigious and people are starting to assert their rights, but not everything is a data breach. If it can be corrected, it can be cured, and it can be curbed before the reputation gets out of hand. In such a case, to tell you the truth, what I would probably do, if the case is a lie and it is proved to be a lie and it is proved to be something that doesn't stand in court, I'd probably even pursue defamation or libel proceedings, because I have very high chances of getting some sort of remedy or damages from the court as opposed to going before the ODPC. But it's all a matter of perspectives and circumstances and where does your strength lie, ODPC or other courts.
Thank you so much, Janet. And maybe also just to add there, that thing, depending on the in-house counsel who you are supposed to send that email to. And then you arbitrarily, randomly sent it to info at the whole organization. Your client will deal with you before they even decide whether they are taking you to ODPC or not, okay? Depending who your instructing officer is within the organization. And the dealing can be very simple. Just move the file to someone else if they're really not happy and they're not satisfied with how you're handling the matter. So in as much as, yes, the question on is it a data breach is something that is subject to the legal threshold that has been stipulated for assessing what is a breach and what is not. I agree with Janet, it probably is not. But there will be ramifications for your business. Since this is lawyers are here, there'll be ramifications for your business in terms of how your relationship goes with your client and your instructing officer, because they will not be pleased, for example, if this is information that the rest of the staff, they did not want the rest of the staff to know, regardless of what the Data Protection Act says about it being a breach or not. It may not be a breach, but again, the confidentiality with which your instructing officer wanted the brief handled was not followed in this particular issue. It becomes you may find yourself having problems with your client and your fee not being transferred to someone else. That is all I wanted to add.
Sorry, just before I conclude, one of the things that through the Law Society National IP and IT Committee that we've been trying to push is to have an engagement with the ODPC so that we see how, as lawyers and law firms, we can get very sector-specific sort of regulations that tie into what we've been doing, because ours is essentially
confidentiality,
and it has its own dynamics and it has its ways in the common law and in our Civil Procedure and Advocates Act. So it's not easy for us to shift gears and to fully comply when we have this other set of operating procedures that it require us to name parties to pleadings, require us to serve openly, require us to get a signature. And when you're serving, people dismiss you and run away from you, and you have to show effective service. So those are some of the dynamics that the national LSK national office has been trying to have discussions with the ODPC to see how we can get some sort of synergy in terms of our existing laws and practice and the extra layer of Data Protection Act that we need to have as law firms and lawyers.
Thank you so much, Janet. That is very important. And now the last question. Okay, sorry, I'm seeing some more comments here from Sharon Massey. In addition to that question on pleadings, with the new Data Protection Act, does it mean parties in a suit can now opt out of being named in full? Use of name, considering that pleadings are a public record? The answer to that question is no. This is because the Data Protection Act provides for you to be able to use personal information as provided for in any other written legislation. Obviously, the practices of the court in terms of how pleadings are filed, how parties are named, and all those things are subject to other acts of parliament, as well as practice directions from the Chief Justice. So for now, no, because there's a legal basis for such naming of suits. But in future, maybe the ODPC and the Chief Justice will meet and decide otherwise, and that will change at that point. But for now, no, it is not an optional activity for parties to acclaim. It is currently not. Yeah, okay. So then the last question is from Michelle, which was on the chat addressed to me. So it says to Mercy, what data protection compliances are required for personal data collected indirectly by data controllers through deliberate publication by data subjects? For example, will clubs be liable under data protection laws if they post images from the data subjects' Instagram accounts on their official social media accounts? So, Janet, I see you have opened your camera, and I was going to say this is actually very closely related to what Louisa had shared earlier about consent under data protection not exactly being synonymous with copyright, rights of the data subject there. So what I would say, wisdom to the clubs: if somebody posts their photo on social media deliberately and you want to reuse it, the repost button is your best friend. Okay, that is your best friend. Repost. Do not grab the photo and then go and create your own post, because then that will create a conundrum of issues for you. The repost button is your best friend. In case it is a social media platform where there's no repost, please just note, if you create a new post, the person can actually take issue with you from a copyright perspective, as well as from a data protection perspective, in terms of if you are using or you're doing that post for commercial purposes, marketing, brand awareness, PR, commercialization, to get yourself more customers. That, is the proverbial opening a can of worms that shall come to eat you. Yes, Janet?
Nothing to add.
Thank you very much. And with that, we hereby come to the end of this webinar. Thank you so much, everybody, for being a part of this. You've been a wonderful audience. Thank you for the questions. Thank you for hanging around. We've been over 100 this entire time. So thank you very much. And I think we'll close it here just because of time. We are half an hour beyond. So thank you so much, and see you. In case you have any additional questions, you can always send it to the LSK Nairobi Branch Secretariat, and we can always organize a part 2 for this. Thank you so much. And goodbye. I think I'll let everybody drop off as they wish. And maybe as people drop off, I shall play you an entertaining song. But please feel free to leave.